Many Americans believe they live in a free country governed by the Constitution and the rule of law. We hold these truths to be self-evident, enshrined in our founding documents, and passed down through generations. We cherish our freedoms, our right to life, liberty, and the pursuit of happiness. But what if this perception of freedom is just that, a perception? What if the legal bedrock of our nation has shifted beneath our feet, largely unnoticed? This is the hidden history of U.S. law, a story of subtle shifts and seismic changes that have reshaped our legal system. It's a story that begins not with fanfare and revolution, but with seemingly innocuous legal decisions, bureaucratic maneuvers, and economic policies. It's a story that unfolds over decades, hidden in plain sight, its significance lost in the complexities of legal jargon and the relentless march of time. This is not a story of conspiracy, but of consequence. It's a story about how the American legal system, once rooted in common law and individual liberty, has increasingly shifted towards an administrative and contract-based system. To understand this transformation, we must journey back to three pivotal years: 1938, 1946, and 1965. These years marked turning points in American legal history, moments when seemingly disparate events converged to alter the course of our nation's legal DNA. In 1938, Erie Railroad versus Tompkins redefined contracts in the legal system. In 1946, the Administrative Procedures Act reshaped government structure. By 1965, the rise of the UCC and administrative state was evident. These years reveal a shift towards administrative dominance and contractual obligations. These three pivotal years reveal a clear trend: the erosion of common law principles and individual liberties in favor of a system dominated by administrative agencies and contractual obligations. This shift has profound implications for the way we live, work, and interact with the government. It impacts everything from our financial transactions to our interactions with law enforcement, often in ways we may not even realize. As we delve deeper into each of these pivotal years, we will uncover the hidden history of U.S. law and examine how these seemingly disparate events have combined to create the legal landscape we navigate today. By understanding the past, we can better equip ourselves to navigate the present and shape the future of justice in America. This is not just a story about law, it's a story about freedom, power, and the future of our nation. This shift towards a more contract-centric legal system had significant implications for businesses and individuals alike. Our story begins in 1938 with a seemingly straightforward case involving a railroad accident. Harry Tompkins was struck by an object from a passing freight train and sued for negligence. This case would become a landmark decision, altering American law. The Supreme Court ruled that federal courts must apply state law in diversity cases. This ruling, known as the Erie Doctrine, shifted power towards state law. Section 2. Contracts as king, elevating agreements above common law. While the Erie Doctrine might seem like a technical legal matter, its impact on the American legal landscape was profound. By requiring federal courts to apply state substantive law in diversity cases, the Erie decision effectively elevated the role of contracts in the American legal system. This is because many areas of law, particularly those involving business and commerce, are governed by state contract law. Prior to Erie, parties could often rely on federal common law principles of fairness and equity in contractual disputes. However, after Erie, these disputes were increasingly decided based on the specific terms of the contract itself, as interpreted under state law. This shift towards a more contract-centric legal system had significant implications for businesses and individuals alike. For businesses, the Erie Doctrine meant that they could no longer rely on a uniform body of federal common law to govern their interstate transactions. Instead, they had to navigate a patchwork of state contract laws, each with its own nuances and interpretations. This increased complexity and uncertainty in the legal environment, particularly for businesses operating across state lines. For individuals, the Erie Doctrine meant that their rights and obligations in contractual relationships were increasingly determined by the fine print of the agreements they signed, rather than by broader principles of common law fairness. This shift placed a greater burden on individuals to understand the terms of the contracts they entered into, as they had less recourse to challenge unfair or unconscionable provisions under state contract law. Section 3. The diminishing role of the jury, from fact-finders to rubber stamps. The shift towards a contract-based legal system diminished the jury's role in civil cases. Judges, with their legal expertise, took over interpreting contracts, reducing jury trials. This shift favored those with resources to hire sophisticated legal counsel. The decline of jury trials represented a loss of a fundamental check on judicial power. Section 4. A Nation of Contracts. The pervasive impact of Erie, the legacy of the Erie Railroad versus Tompkins decision is all around us. It's in the fine print of the contracts we sign every day, from our mortgages and car loans to our cell phone agreements and online terms of service. It's in the increasingly complex and specialized nature of the legal profession, where lawyers often focus on narrow areas of contract law. And it's in the subtle shift in the balance of power between individuals, businesses, and the government. The Erie Doctrine, by elevating the role of contracts in the American legal system, has contributed to a world where our rights and obligations are increasingly defined by the agreements we make, rather than by broader principles of common law fairness. This shift has profound implications for the future of justice in America, raising concerns about individual autonomy, access to justice, and the very nature of the American legal system. But the story doesn't end there. The Erie decision was just the beginning of a series of legal and political shifts that would further transform the American legal landscape in the decades to come. As we'll see in the next chapter, the rise of the administrative state and the adoption of the Uniform Commercial Code would further solidify the dominance of contracts and administrative regulations in American law. These changes would have far-reaching consequences for individual liberty and the rule of law. As the dust settled on World War II, America emerged victorious, but forever changed. The war effort demanded unprecedented government intervention, reshaping the relationship between citizens and the state. Rationing, price controls, and centralized production became the norm. In 1946, Congress passed the Administrative Procedures Act, or APA. The APA established a framework for administrative agencies to create and enforce regulations. These agencies were granted broad authority to interpret and implement congressional mandates. Critics argued it violated the separation of powers, granting unelected bureaucrats legislative and judicial functions. The Administrative Procedures Act marked a turning point in American governance. It ushered in an era where administrative agencies played a dominant role, often bypassing traditional checks and balances. This new governance created a complex web of regulations, enforced through administrative courts. Agencies could interpret and implement mandates with wide latitude, often behind closed doors. This shift impacted the balance of power, favoring unelected bureaucrats over elected representatives. The shift towards administrative governance also had significant implications for the traditional notions of due process and the right to a fair hearing. The APA, while establishing some procedural safeguards, also created a system where individuals and businesses facing enforcement actions by administrative agencies often found themselves at a distinct disadvantage. In many cases, administrative agencies acted as prosecutor, judge, and jury, investigating alleged violations, conducting hearings, and imposing penalties. This concentration of power within a single entity raised concerns about fairness and impartiality, particularly since administrative law judges were often employed by the same agency responsible for enforcing the regulations in question. Furthermore, the rules of evidence and procedure in administrative hearings differed significantly from those in traditional courts. Hearsay evidence, inadmissible in a court of law, was often permitted in administrative proceedings. The burden of proof was often shifted to the accused party to prove their innocence, rather than the government bearing the burden of proof beyond a reasonable doubt. These procedural differences, while perhaps justified by the need for efficiency and expertise, often resulted in a lower standard of due process for individuals and businesses facing administrative enforcement actions. The erosion of due process within the administrative state represented a significant departure from traditional American legal principles. It created a system where individuals and businesses could be subject to significant fines, penalties, and other sanctions without the same level of procedural protections afforded to criminal defendants. This shift raised fundamental questions about the balance between individual rights and government power in an increasingly complex and regulated society. Section 4. From citizens to regulated entities, a fundamental shift. The rise of the administrative state and the passage of the Administrative Procedures Act marked a fundamental shift in the relationship between the American people and their government. No longer were citizens viewed primarily as rights-bearing individuals entitled to due process and the protection of the law. Instead, they increasingly became regulated entities, subject to the vast and often opaque rules and regulations promulgated by unelected bureaucrats. This transformation did not happen overnight. It occurred gradually, often subtly, as administrative agencies expanded their reach into virtually every aspect of American life. From the food we eat to the cars we drive to the air we breathe, administrative regulations touched nearly every facet of modern existence. While many of these regulations were well-intentioned and aimed at addressing legitimate public health, safety, and environmental concerns, the cumulative effect was a society increasingly governed by rules rather than rights. The rise of the administrative state also had a chilling effect on civic engagement and political participation. As the regulatory state grew more complex and opaque, it became increasingly difficult for ordinary citizens to understand, let alone influence, the decision-making process. This sense of powerlessness and alienation contributed to a decline in civic engagement and a growing distrust of government. The shift towards an administrative and regulatory state was one of the most significant developments in American legal history. While often overlooked or misunderstood, its impact on the relationship between citizens and their government, the balance of power within the federal system, and the very nature of American democracy has been profound and enduring. Section 1. Silver removed the end of sound money, the rise of debt. The year 1965 marked a turning point in American monetary history. Silver was removed as a means to pay debt, shifting towards a debt-based monetary system. This paved the way for a fully fiat currency system. The dollar became a debt instrument, leading to rising debt and financial crises. Section 2. A Uniform Code for Commerce, the UCC and the privatization of law. The Uniform Commercial Code, UCC, harmonized commercial laws across the U.S., simplifying transactions. It replaced inconsistent state laws, easing nationwide business operations. The UCC's privatization of lawmaking raised concerns about transparency and accountability. Section 3. Admiralty courts on land, a shift from justice to commerce. In 1965, admiralty law began expanding into everyday commerce, shifting from maritime disputes to business contracts. Admiralty courts, traditionally for shipping disputes, started handling commercial cases, emphasizing written contracts. This shift raised concerns about due process and fairness in business disputes. Section 4. Intent. The new burden of proof. The removal of silver, adoption of the UCC, and expansion of admiralty law shifted the burden of proof from the state to the individual. Individuals now had to prove they did not intend to enter contracts or understand terms, complicating legal disputes. This shift raised concerns about fairness and access to justice. The illusion of freedom, trapped in a web of contracts. As we've journeyed through the hidden history of U.S. law, we've uncovered subtle shifts that have reshaped the legal landscape. What began with the Erie Railroad case in 1938 gained momentum with the rise of the administrative state in 1946, and culminated in 1965 with the removal of silver, the adoption of the UCC, and the expansion of admiralty law. This has fundamentally altered the relationship between the individual and the law in America. We live in a world increasingly governed by contracts, where our rights and obligations are defined by the fine print of agreements we may not even understand. The illusion of freedom persists, but the reality is that we are often bound by a web of contracts. A shifting burden from presumption of innocence to proof of intent. The principle of innocent until proven guilty is eroding. Contract-based law emphasizes intent, shifting the burden of proof. Individuals must prove they didn't agree or intend to violate regulations. This shift is evident in administrative law. Agencies act as prosecutor, judge, and jury. Small businesses face an uphill battle against bureaucratic systems. The presumption of innocence feels like a distant memory. This has a chilling effect on individual liberty. But the American spirit of independence still burns bright. By understanding these shifts, we can restore balance. Reclaiming our legal heritage, a call to awareness and action. The first step towards reclaiming our legal heritage is awareness. We must educate ourselves and others about the shifts in our legal system. Awareness must be followed by action. Engage in the political process, contact officials, and support organizations. Demand reforms that protect our freedoms and ensure justice. This is an American issue. Our rights are under threat. We must reclaim our legal heritage for future generations. Restoring the balance towards a just and equitable legal system. Restoring the balance in our legal system requires legislative reforms, transparency, and accountability. Judicial vigilance is essential to uphold the Constitution and protect individual rights. An engaged citizenry must hold elected officials accountable. We must prioritize fairness and justice over efficiency. The future of freedom depends on confronting uncomfortable truths and demanding better. Justice must be a right guaranteed to all.